Hi, I'm Steve Adelman, and this is Adelman on Venues. A lot of what I'm being asked these days about reopening relates to legal issues about waivers of liability. People are starting to feel more comfortable with the idea that they can reopen, but now they're starting to worry about, well, all the workers and patrons and maybe they're going to get sick and maybe they're going to sue. So is there something legal that I can do to protect myself? And people gravitate towards waivers of liability, the tiny font language that we're used to seeing on the backs of tickets and on websites and stuff. And they're asking me, hey, Steve, can I make people sign a waiver of liability? And my answer is, you can. I don't particularly think it's going to help. And they say, what? And then I have to give this long rap. So I'm recording now what is normally the rap that I give about waivers of liability, because I think that you should understand what a waiver is and how it's used and why, for the purpose of reopening, it's not actually the Swiss Army knife tool that many people think that it is. And well, I want you to understand. So let's try this. Let's go through some slides that I've prepared and have a conversation about waivers of liability. So this is an Ask Steve. I've done 2 of these already, and today will be the 3rd. So I'm going to clarify that this Ask Steve is, well, it's my Ask Steve. I found out that Steve Harvey, the talk show host, also had an Ask Steve, and so I'm clarifying, this is Ask Steve Adelman, because be careful about how people understand things. Today's Ask Steve Adelman is about waivers of liability. So that's what we're going to talk about. What are waivers? Well, let's just ask the questions. Let's tee them up the right way. So, are waivers of liability enforceable? Should I make my workers and patrons sign them? There, those are the basic questions. Let's just dive right in. Are waivers of liability enforceable? Yeah, rarely. I mean, more than never, but not usually. Usually waivers of liability are interpreted to go to notice. They're interpreted as notice of a risk and notice that someone had some information provided to them about the risk, and then the analysis will proceed. But will waivers of liability be enforced as a strict bar against somebody suing? No, not usually. So should I have my workers and patrons sign a waiver of liability? Well, given that they're rarely enforced, yeah, maybe. I personally don't recommend them to my clients. I'm not giving you legal advice on this webinar, but for the purpose of this webinar, I'm not a big fan. Let's explain why. So it's easiest to explain waivers of liability with an example. As it turns out, Today and its news provides us with an example. So this is the waiver of liability provided by the president's campaign, because they're doing a campaign rally in Tulsa, Oklahoma next Friday. It's Juneteenth. And this is their waiver for people who would attend the Trump rally at an indoor arena. And well, let's just read it, and then we can discuss waivers of liability, and then we'll come back and apply what we've learned to decide, well, to at least contemplate the extent to which this waiver language is enforceable. But first, let's start by reading it. It says, again, this is the exact language from the Trump rally registration site for next Friday's rally. By clicking register below, you are acknowledging that an inherent risk of exposure to COVID-19 exists in any public place where people are present. By attending the rally, you and any guest voluntarily assume all risks related to exposure to COVID-19 and agree not to hold Donald J. Trump for President, Inc., BOK Center, ASM Global, or any of their affiliates, directors, officers, employees, agents, contractors, volunteers liable for any injury or illness. So that's the waiver of liability language, and assuming that you're okay with that, you click register and you're allowed to go. There, that's the example. We'll come back to it when we've discussed some law. Let's discuss some law. The legal concept of a waiver of liability is it's a contract. And I'll discuss the three elements of a contract in a minute, but let's discuss the basic idea of a contract first. The idea of a contract is people or businesses agree to something. They reach some agreement. They have discussions, they negotiate back and forth. They have roughly equal bargaining power so that they're able to negotiate back and forth, and they eventually reach some conclusions, and that's their agreement. And as a matter of law, it's called a meeting of the minds. At least that's what cases used to refer to it as. So this meeting of the minds concept is more or less the idea behind a contract. People agreeing to terms that they both understand because they have negotiated them. And the contract simply has to be legal wherever it's made. You can agree to more or less anything. The contract is the agreement. The piece of paper called contract or agreement or subcontractor agreement or agreement for services, that's not the contract. That's just the memorialization of the contract. It makes it easy to not argue about what the agreement was later once people forget. But the contract itself is these three things. There are three elements to a contract. They are offer, acceptance, and consideration. Consideration just means payment. It can also mean foregoing the right to do something that you're legally allowed to do, but mostly in our context, it's payment. So the only things that you need to know about offer and acceptance is the offer has to be legal wherever it's made, and the acceptance has to be accepting substantially what was offered. So if somebody accepts terms that for some reason were not the terms that were offered, that's just a counteroffer. Don't worry about that. Offer, acceptance, consideration, voila, a contract. And then if somebody writes it down, so much the better, makes it easier for lawyers later. So now that you understand the concept of a contract, let's go to waivers. Here's the problem. It's actually several problems. The first one is unequal bargaining power. Remember that meeting in the minds idea? It doesn't work when one party has all the power and says, here are my terms. If you like them, great. If not, get lost. That's not equal bargaining power. And as a matter of public policy, courts hate enforcing contracts that represent unequal bargaining power. Contracts with unequal bargaining power are referred to as adhesion contracts, and adhesion contracts are rarely enforced per se. Instead, they are simply used as notice, as a warning, just like a sign or language on a website. So the fact that it's in a tiny font size on the back of a ticket, back in the old-timey days when people printed tickets, didn't mean that somebody's claim was completely barred, at least not recently. Rather, it simply meant that that was another form of warning, and then the court would look to see, did each party have a duty of care? Did anyone breach their duty? Was anyone's breach the proximate cause of some resulting harm? So the court would simply go through the usual four elements of a tort. So adhesion contracts, of which waivers of liability are an example, rarely enforced because of the unequal bargaining power. Also, waivers of liability are susceptible to not being enforced because of the issue of informed consent. In other words, somebody has to know what rights they're waiving. And that's problematic with COVID-19 because no one really understands COVID-19. The epidemiologists are struggling every day to really get their arms around it. So how could somebody going to a rally or a club or a sporting event really be assumed as a matter of law to fully appreciate the risk? Probably courts are going to be very reluctant to enforce a waiver because not only of the unequal bargaining power that makes every waiver hard to enforce, but also the particular circumstances of COVID-19, which clearly we don't fully understand. All we know is it's bad. That's going to make waivers harder to enforce. Let's go deeper. There are four basic litmus tests, 4 prongs to the analysis of should a waiver of liability be enforced. So spoiler alert, again, the answer generally is going to be no, but let's work through the analysis so that we understand why, and then we can apply it back to the waiver language that we just saw a few minutes ago. So again, 4-prong test. Here's the first. Is there a duty to the public? Well, you know the answer to that is yes, because the duty of every venue, including this arena in Tulsa, is to maintain premises that are reasonably safe under the circumstances of a global pandemic when there's not enough testing, no contact tracing, and no vaccine, at least not on the distant horizon. So is there a duty of care? Yes, there is. 2, does the waiver relate to a service that is essential? Well, if I can loosely characterize a political rally as a form of entertainment, which I think is fair, then the waiver relates to something which is not considered essential or necessary as a matter of law. Personally, I find this a little insulting because sports and entertainment are not considered essential or necessary as a matter of law. And I'm thinking that one of the lessons of the stay-at-home orders and how nuts we're all getting already is, turns out sports and entertainment are more necessary, more essential than perhaps the law originally contemplated. But at least for right now, waivers of liability arising from entertainment-related events will tend to be more likely to be enforced because no one has to go to an entertainment event. No one has to attend a political rally. So given that you always have the option of saying, I'm not cool with this risk, the waiver will tend to be more enforceable. All right. Let's go to prong 3. Was the waiver fairly entered into? Well, we've already discussed that. That's going to be problematic because no one really understands COVID-19, and the idea of informed consent is going to be very difficult just because of how little we know about this particular virus. And then 4, was the scope and intent of the waiver expressed in clear and unambiguous language? Usually that's a pretty laughable proposition. Lawyers don't get trained to write in clear and unambiguous language. There are words that no one ever speaks that routinely show up in legal documents, whereas and heretofore and, all sorts of other silly polysyllabic words that, no one has ever said in conversation. And yet, when we get to the Trump waiver, I think it is fair to say, voluntarily assume all risks related to exposure to COVID-19. Yeah, that's pretty clear and unambiguous. I get that. I don't think you have to be especially smart or a lawyer to understand what those words mean. So at least the 4th element of the 4-prong test, yeah, I think that's going to pass muster. So I don't have an answer. Clearly, no one has challenged this particular waiver language, and I don't know if anyone will. But if someone does, I suppose we all get to play the parlor game of, is this language going to be enforceable by any court of law? And, I don't have an opinion that's worth venturing right now, and I think it's more constructive to leave it up to you. So I'm going to do that. But I'm not going to leave the conversation there because I think there's a more constructive place to end. And here's the more constructive place. The more constructive place starts with an analysis of baseball. I remember baseball. I like baseball, and I'm hoping that one bright day it comes back, preferably on a day when it's safe to do so and not just because somebody says we need to monetize the rest of the season. So I'm going to teach you a little about the baseball rules so that you understand a little about waivers of liability and why it's so difficult to enforce them by analogy. So this arose from a conversation I had earlier today where somebody said, Steve, you're saying that waivers of liability are hard to enforce, but what about the language on the back of a baseball ticket? That's easy to enforce. And there's a reason for that, and it's called the baseball rule. So little detour to the baseball rule. Baseball rule in a nutshell is the first sentence written here, which is, In analyzing the scope of the ballpark's duty to spectators, we first consider whether the risk of injury from foul balls is open and obvious. The reason that's the first consideration is, as a matter of law, if a risk is open and obvious, then there is no duty to warn of its existence. You don't have to warn the Grand Canyon is a steep drop because anyone who looks can see it. There's no duty to warn of the risk of baseballs flying through the air. Oh, but there actually is quite a lot of signage. And here's why. Because open and obvious is in the eye of the beholder. And so the baseball rule is not nearly as ironclad as it used to be in the tougher days when a rule was a rule. Now things are much more relative. And I think we're a more compassionate society when we don't enforce the open and obvious rule against little kids for whom the threat of flying baseballs is not either open or obvious. Same thing in this case. This was a case where a little boy was sitting with his family at these picnic tables. And not only did he not appreciate the risk of getting hit by a baseball, but the ballpark put the tables in perpendicular to the ball flying out away from home plate. And so little Emilio Crespin not only could not appreciate the risk because he was little, but also the ballpark had a duty that arguably it breached by putting up tables where people would necessarily not be looking at the path of the ball. And so in that case, the Albuquerque Isotope settled and they paid some money. So the waiver of liability was not effective as to little kids. Well, here's a grown-up. This is Bud Roundtree from Boise, Idaho. And well, he was a season ticket holder at the AAA team in Boise for many years. And he even had this good language on the back of his ticket. This is the actual language, which was in all caps. The holder assumes all risks and dangers incidental to the game of baseball, including specifically, but not limited to, the danger of being injured by thrown or batted balls. Pretty clear. Tiny font size. Doesn't really matter because Bud Roundtree never read it anyway. Does that mean that he lost? That this language on the back of the ticket was binding and barred his lawsuit? No, it went to notice. It was part of what Bud Roundtree was discussed as having some comprehension about, and then the question went back to who had a duty of care, was there a breach, was anyone's breach a proximate cause of Bud Roundtree's resulting harm, the usual 4 elements of a tort. Here's a fun one. This is the case involving Slugger. Slugger with 3 R's at the end of his name is the mascot for the Kansas City Royals, or he was anyway. And Slugger tossed hot dogs into the stands. And in this particular instance, Slugger was standing on the roof, the dugout roof for the Royals during the game, and there was nothing going on, and he was tossing hot dogs, and Mr. Coomer was not paying attention and took a wrapped hot dog in the eye and suffered retinal damage. Did Mr. Coomer lose because there was language on the back of his ticket? No. Did he lose because the danger was open and obvious? No, he got to have his day in court. And so the waiver of liability simply went to notice. The claim was not barred. So in all these baseball cases, open and obvious was very subjective, and the court was willing to consider it and let people have their day in court. Going back to the Trump waiver, the president is already on record as saying that COVID-19 is the invisible enemy. This was March 17. I can barely remember that far back. But he called it the invisible enemy even then. So I think saying now that the danger of COVID-19 infection is open and obvious wouldn't be an easy thing to sell to any court, not only because the epidemiologists are clearly saying we don't fully get it, but because the president is already on record as calling it invisible. So that open and obvious thing, that's not going to work for him. That's why the baseball rule analogy does not hold at all here. So now are we done? No, because you don't actually need a waiver anyway. You don't. And the reason you don't need a waiver, so all this discussion about why they're not generally enforceable is a matter of public policy. There's no informed consent. COVID-19 is not something that we understand anyway. The four-prong test, you didn't need to go through all that. I did because people keep asking. But you don't actually need a waiver of liability anyway, because you don't have to worry about an army of personal injury lawyers banging down your door. Personal injury claims arising from COVID-19 are losers. They're losers because of the elements of a tort. Four elements are duty, breach, causation, and harm. And if you haven't already, there's a fine video for you to watch. Oh, look, it's the second of the third, this is the third Ask Steve episodes, where I discuss liability. And I explain in really pretty substantial granular detail why you don't have to worry about losing personal injury lawsuits arising from COVID-19. So a waiver of liability would be asking someone to waive a right to sue for something that is not valuable. They are going to lose if they sue based on injuries from COVID-19. So watch the second video, liability, and you'll understand that. But as for everything else, waivers are just not very enforceable, and you don't really need them anyway. Now are we done? No, because all I've done so far is bash something without giving you anything constructive. And I am nothing if not a positive and constructive person. So let's finish on a high note. Let's finish with Disney. Let's at least get close to the finish, and Mickey and Minnie are going to take us there, because as is often the case, Disney is the gold standard. I mean, they just do so many things right. And it's really a pleasure to just know that I can comfortably look on a Disney website and find something smart. And they're not paying me for this. It's just been my experience that you can learn a lot from the big mouse. And in this case, the thing to be learned is how they avoid getting tangled up in this stupid waiver of liability argument. So here's their homepage for phased reopening of the Disneyland Resort set to begin in July. And what I've highlighted there is the particular line that starts just like the Trump waiver. An inherent risk of exposure to COVID-19 exists in any public place where people are present. Well, that's very similar to the language we've already read twice. But look at the rest. View important details. Rather than saying, hey, if you decide to come, you're waiving your right to sue. Mickey and Minnie don't say that. They're not holding something over your head. No, they're saying, we have information. We want you to be informed. We want you to understand what it will mean for you and your family to come to one of our Disney parks. And we want you to do it safely and confidently, because we're all about building generations of people who love our Disney experience. And so we're not going to basically threaten you. No, we're going to inform you. We're going to provide you with valuable information from smart people. And if you follow the link, view important details, it'll take you to science, and it'll take you to recommendations about how to keep yourself and your family safe. And I think that's great. And I think that's exactly what we should be doing. Rather than trying to wiggle out of legal exposure, no, tell people the things that they need during a pandemic so they can make a good choice, especially when their family's involved, but really anyone. Help people make a good choice. That's the compassionate thing to do, not struggling for some legal out that doesn't really exist anyway, that you don't actually even need. No, take the high road. Give them information. Help them be healthy. That's the right thing to do. And you know, if you want to lead people to guidance, there are lots of forms of guidance out there now. The Event Safety Alliance Reopening Guide came out more than a month ago. We released it on May 11, and now we're into translating it into various foreign languages. Here are the French and Chinese versions, which I think is really cool. And it doesn't really matter to me what language you read or whose guidance you use, but use something. Send people to some information that will help them make a good decision, because that's the way you cement a positive relationship based on trust and confidence, not on getting out of some legal risk. Work together with people. I mean, I can't believe that a lawyer has to discuss morality and ethics. You know, legal ethics is almost an oxymoron, and yet here I am doing that because after having spent this time discussing waivers of liability and the law surrounding it, my conclusion is it's not worth it. It doesn't yield much benefit, and it's not a good thing to do anyway. So I guess really what I'm saying is, trying to stop my share so I can look you in the eye. What I'm saying is, don't bother. This is not the way you want to spend your time finding waiver of liability language. Don't do that. Instead, inform your patrons, give them information, let them make a good decision. Be their partner. And that way you'll reopen and you'll stay open, because people will say, they treated me fairly. They treated me fairly. That's what you want. So there. I have posed the question in the Ask Steve Adelman, and hopefully that is a satisfying answer which not only addresses your legal concern, but also takes you to a place that's more valuable than, in this case, the legal answer, which is not especially useful. So with that, I am Steve Adelman. This has been Adelman on Venues. Thank you for your time and attention. Watch the other 2 videos of Ask Steve. They'll answer other legal questions of yours. And I will doubtless do more of these in the future. So thank you.